We are
All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Well, thank you for the court cry, Shernette. We are not opening the session. As you know, we have previously conducted the hearings on the first two of the cases on our hearing list this morning using our Zoom video conference platform. This is a continuation of the hearing list. We have 4 cases remaining, the first 2 of which are criminal and the remaining 2 of which are civil in nature. We will not be taking a break during the remainder. We will hear the arguments in all 4 cases in succession. Those of you who have been here before understand the dynamic. Each side has 15 minutes to argue. There is no rebuttal. We're familiar with the arguments that you've made in your brief and the factual and procedural background in each. You need not repeat that. We will have questions for you. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever we do not reach. If you reach the end of your argument before you reach the end of your time, you need not continue. With that, I'll call the first case, case number 2022 P1059, the Commonwealth versus Dwayne J. Richardson.
Good morning, Your Honors. My name is Edward Gaffney, and I represent the defendant, Dwayne Richardson. We're here on Mr. Richardson's appeal from the denial of his motion for a new sentencing hearing. Just a quick procedural note. When I brought the motion for a new sentencing hearing, I brought at the same time a motion for a new trial. That motion is still pending before Judge Deakin. It was brought with on essentially the same grounds as the Commonwealth versus Anthony Dew case, which was recently decided in the SJC with respect to the racist and bigoted Facebook posts made by Mr. Richardson's attorney. In light of the Dew case, Judge Deakin allowed a motion for a stay of execution of sentence, and therefore Mr. Richardson is able to join us today. So turning to the first argument I made in my brief, I believe that the Perez decision controls entirely this case. This court went to considerable lengths in Perez, I believe, to explain exactly what the Commonwealth needed to do in the circumstances of a case in which they sought to enhance a sentence in an ACC setting based on an assault.
Do you say that is? Do you say that absent a transcript or the actual a plea agreement that the Commonwealth, there's no other sufficient evidence that they could put on?
No, Your Honor. Anything that would be evidence of what happened at the plea. I mean, you could have the testimony of anybody who was there at the plea colloquy to what the defendant admitted to. Anybody could testify.
Do we know if Officer Boyle was at the plea colloquy, at the plea?
I don't think the record reflects whether he was at the plea. I do know that the record does not reflect that Officer Boyle actually testified to what happened at the plea. So there was no evidence in this case introduced by the Commonwealth of what happened at the plea. So we're clear on what the Commonwealth's allegations were. We're clear on what the version of events that Officer Boyle testified to, but we aren't clear on what the defendant admitted to at the guilty plea hearing.
Do you agree that if that Officer Boyle's testimony was sufficient to show that it was not an offensive assault and battery on a police officer?
Well, that's essentially the argument that the Commonwealth makes, I believe, Your Honor. Yes, I concede that the facts as testified to by Officer Boyle would constitute a harmful battery and therefore would be sufficient as, sufficient grounds for finding of a violent crime if the Commonwealth were able to tie that description of events to what the defendant actually admitted to. But I believe that the Perez case makes clear that it's not about what Officer Boyle testifies to that happened to him or with him and the defendant. It's what happened at the plea hearing. So it's, in my view, Perez speaks directly to this circumstance. Now, there was a difference in Perez because the officer in that case testified in a manner in which the facts were somewhat ambiguous. And what the court in Perez said was, even if the judge could have determined that the defendant had admitted to those facts, the Commonwealth still wouldn't have carried its burden because it was ambiguous. So we can't know beyond a reasonable doubt, or a finder of fact couldn't find beyond a reasonable doubt, that the defendant had actually admitted to a harmful battery.
That goes to the nature of the underlying offense, doesn't it? It seems the distinction you're drawing is between the evidence that was actually admitted to at the plea hearing.
Exactly, Your Honor.
And the facts underlying the conviction that entered as a result of the admissions at the plea hearing. If there is no ambiguity in the description of the incident that gave rise to the conviction, as there was in Perez, does Perez really control in the way that you're describing?
It does, Your Honor, because the ambiguity has to do with the way that the officer testified to his version of the events. Nothing in either case, Perez or the case that we're here arguing, there was no evidence of what actually was testified to or put forth as the Commonwealth's case, and there's no evidence as to what the defendant actually admitted to. As Perez makes clear, just because the Commonwealth's evidence or the Commonwealth's allegations are one thing doesn't mean that the defendant is going to admit those at the guilty plea itself. And that's what controls, because what he is convicted of.
In the absence of the kind of ambiguity that was present in Perez, wouldn't it be an ordinary presumption based on the principles of regularity that the description of events at the plea hearing would be consistent with the descriptions of events in the subsequent proceeding? What reason would there be in this circumstance to believe that the underlying incident would have been described in terms differently at the plea hearing than they were at the sentencing hearing?
Thank you, Your Honor. Any number of things. I mean, the plea negotiations themselves may have led to a clarification. And the defendant may have disputed the version of events that Officer Boyle testified to, and the defense attorney and the ADA may have come to an agreed-upon set of facts that did not constitute harmful battery, but in fact constituted reckless battery. I mean, that's just one possibility, and that's spoken to directly in Perez. The holding in Perez specifically says we can't know what the defendant is, we just can't know what the defendant testified to, what the defendant admitted to at the plea hearing. We can't assume that it is as described by, in this case, Officer Boyle. And so without that tie, which Perez makes clear must be present, the Commonwealth hasn't put in sufficient evidence to carry their burden. A finder of fact can't find beyond a reasonable doubt what happened at the plea hearing with no evidence of what happened at the plea hearing. That is the essence of my argument. And I would take issue with the Commonwealth. I think it was in a footnote in his brief, speaks to what it seems to characterize as some tension between Perez and some of the language in SJC cases, which say that the language in the SJC cases, which implies that the Commonwealth's burden in an assault and battery ACC setting shouldn't be hard. If the defendant actually did commit a harmful battery, it shouldn't be hard for the Commonwealth to carry its burden. I don't think Perez is in conflict with that at all.
The court found it beyond a reasonable doubt, right?
I'm sorry, Your Honor?
The court found it beyond a reasonable doubt, thank you, that the officer's testimony satisfied the harmful battery.
In this case?
Yes.
Yes, Your Honor, and I think that was the error. I think that was an error, that the judge didn't have enough to determine what the defendant was
I
convicted
thought you were
of.
addressing the standard.
No, well, actually, I think I was addressing the Commonwealth's argument that Perez seems to indicate that the Commonwealth's got a tougher road to hoe than some of these other cases in the SJC imply. And my position is, no, Perez doesn't say that. Perez says the problem comes when you've got a guilty plea, and if you're the Commonwealth and you are introducing testimony of the victim witness. That's when you've got a problem with the Commonwealth, with the burden, because you've got to tie it to what happened at the plea. If you don't touch the plea, then a finder of fact is basically doesn't have what they need to find anything beyond a reasonable doubt about what the defendant admitted to, and therefore what he was convicted of. And so therefore I would argue that in this case, the defendant should be resentenced as an ACC level 1, not as an ACC level 2, because I don't think there was a sufficient evidence for that finding.
Why would that be the disposition? Why wouldn't it, why wouldn't it be permissible for the Commonwealth to fill that burden at a new sentencing hearing? To fill that gap and to provide, to fill in the record with the evidence that you're now suggesting should have been present?
Oh, that's a double jeopardy issue, Your Honor. The Commonwealth has already, the trial happened, they put forth their evidence, they didn't carry their burden. The sentencing hearing isn't, in other words, the trial as to whether the defendant was actually guilty of these prior offenses is a separate...
This was not a separate evidentiary proceeding as part of the sentencing hearing. This was part of the underlying trial.
Exactly.
Let me just go back to the Perez case, because as I read it, it says, where the defendant pleaded guilty, a transcript of the plea hearing or a related document such as a plea agreement will be the best evidence of what the defendant was convicted of. If the Commonwealth seeks to use other evidence, however, that evidence must be sufficiently tied to the defendant's plea to support a reasonable conclusion about the facts of the crime to which the defendant actually pleaded guilty. So, doesn't your argument really go to the weight of the evidence? And the judge could have said, well, you know, I'm not persuaded by having a live witness here. I want to see the actual plea documents. In other words, that Perez case doesn't categorically exclude evidence other than the plea hearing transcript.
Oh, no, Your Honor. No, absolutely not. In fact, but what it does say is if you're going to, for example, do what they did here, introduce the testimony of Officer Boyle, you've got to tie it. You have to tie it to the plea. Because if you don't, then we don't know what the defendant actually pleaded guilty to. We don't know what the facts were that supported his conviction. Because the issue isn't what he was charged with. The issue isn't what the allegations were. The issue is what he was convicted of. And in a guilty plea, that's established by the admissions at the plea hearing. So that language, basically, what the court is explaining is the Commonwealth is in trouble if it simply puts in fact it's doomed. If the Commonwealth simply puts in the evidence of the victim witness, this is what happened to me, because...
But that's not what they did here, right? They put in a certified copy of the ABPO conviction.
Right.
And they called the officer to say, okay, officer, tell us what happened.
Right.
You say that's not enough.
Not enough. Not enough. I see I'm running low on time, so I'll just quickly turn to the other issue and say that Attorney Doyle requested that this, it turned out since he was sentenced as a level 2, ACC level 2, he was facing a mandatory minimum 10-year sentence. Attorney Doyle requested that this sentence be imposed non-pro-tunc to the effective date of a sentence that the defendant was already serving. If the judge had exercised her discretion to impose a sentence that way, it would have reduced the time he served by about 1.5 years.
But he would have gotten double time, right? He would have gotten credit for a sentence that he previously served and credit for this, and so that's frowned upon. And he did ask for concurrent time for these convictions, correct?
Actually, he didn't, but he got it. Attorney Doyle didn't do much, but he didn't ask for concurrent time, but he got it. He didn't ask for the minimum, but he got it. He did ask for this non-pro-tunc sentence. He didn't get that. My argument is with his quote-unquote argument. When it came time to convince the judge to exercise her discretion, this is what he said. I think the least he can get, Your Honor, 10 years is an awfully long time, period. That was his entire sentencing so-called argument. And I believe that that is so woefully inadequate. It didn't bring any mitigating
Standard is that better work by counsel would have accomplished something material for the defense.
Correct.
And as you pointed out, they got a minimum concurrent, a pretty good disposition. And what he didn't get is something that, to use Justice Desmond's phrasing, is frowned upon.
I didn't hear that.
Is frowned upon.
frowned
It would
upon.
have been
He's not entitled
extraordinary
to
to have gotten double credit.
He's not entitled to it. But
Not only not entitled to it, it would have been extraordinary. It would have been highly unusual, even in the absence of the rather favorable concurrent disposition.
well, it absolutely would have been unusual, but my argument is that Mr. Richardson had a very unusual background, and none of it was put in front of the sentencing judge, and it is required for a sentencing judge to impose a just sentence to have that information, and she did not get it.
I understand.
Thank you, Your Honors.
For the Commonwealth?
Good morning, Your Honors. May it please the Court, Assistant District Attorney Ryan Roth from Middlesex on behalf of the Commonwealth. Very quickly before I jump into my argument, Attorney Doyle did ask for a concurrent sentence. That's transcript volume 5, pages 37 to 38. So I just wanted to start by saying he did ask for that. He actually, just to quickly comment on the overall sentencing, is that the Commonwealth immediately asked for the mandatory minimum sentence to run concurrent across all counts. So at the time in which Attorney Doyle is arguing the sentencing, the Commonwealth is telling the judge, impose the minimum sentence concurrent. He asks it also be concurrent with the Lynn sentence. And so the court, in fact, did impose the minimum sentence. But I want to first jump to first of all, the motion judge in general did not abuse her discretion in both denying the request, essentially to find that there was insufficient evidence of an ACC 2, and asked the court to impose now an ACC 1, as well as denying the ineffective assistance claims at sentencing. Starting first on the ACC, the Commonwealth did present sufficient evidence for any reasonable fact finder to find that the defendant committed 2 predicate offenses. First, which is not contested, the 2004 Chelsea docket, which was possession with intent to distribute Class B, was a drug offense, a serious drug offense under the statute. And then the Cambridge 2004 docket of assault and battery of a police officer, which the court found, the Commonwealth proved beyond a reasonable doubt, was a harmful battery, not a reckless battery, not an offensive battery. And that finding is important and actually gratuitous because the Commonwealth didn't even ask the court to make a distinction between reckless and harmful. But the court specifically said, I find beyond a reasonable doubt based on the circumstances of this ABPO, in which the facts are basically that the defendant was tackled while trying to be placed under arrest and being aware that he was a police officer. When he gets up from being tackled, he then immediately starts wrestling and fighting the officer, and at one point gets behind him, picks him up, and essentially throws him on the ground. And he also, and he testified to injuries he sustained from that. So those are the facts that supported the assault and battery of a police officer. As this court has commented and is aware, between Ashford, Eberhardt, Cologne, Beal.
The argument is, however, how do we know that those facts were the facts that were recited at the time of the plea?
So we clearly don't know exactly what was recited at the plea, but that is not the requirement as the defense suggests that Perez says. As Justice Hodgens noted, what Perez says is that if you use other evidence, there has to be a reasonable conclusion that it's sufficiently tied to the plea. So the best way to look at this is circumstantial evidence that the defendant's crime was a violent crime under the statute, not direct evidence. So obviously the plea transcript in the agreement would have been the best evidence to establish exactly what he pled guilty to. But what I argue in my brief, and what I think is consistent with the burden described in Mora and Eberhardt and the other SJC cases, is that if the facts establish that this was a harmful, intentional battery, and that the defendant then pled guilty, that's all we need to prove. In Perez, the issue was, and it was raised as a defense in trial, not like this case where it was not raised and alleged that this was a reckless assault and battery. No one's alleged that, and in fact, the facts don't support that. But in Perez, the evidence was so scarce that both of them, I would argue, could be equally probable as a reckless or harmful. So what the court was actually saying, I would argue in Perez, when you get through the dicta, is that when the defendant makes a defense that, no, this wasn't an intentional assault and battery, this was a reckless, and argues the facts of the case, if they are equally probable, then the Commonwealth hasn't sustained its burden circumstantially. What essentially you're left with is equally possible inferences, and the court should err on finding the defendant not guilty.
I will confess to a certain level of confusion, however. I mean, why in the world would the Commonwealth not put on evidence of what the plea recitation actually was?
Well, the short answer is actually didn't exist at this point. It was a 2004 conviction in which the docket no longer had a plea agreement within the file, and it also, the plea transcript had never been transcribed because the defendant had never attempted to appeal that, and given the age, they were unable to obtain a plea transcript. That's my understanding, is that there was no plea transcript that was able to be obtained. It no longer existed. So, and the plea agreement actually probably wouldn't have been helpful because it would have been a standard green sheet in district court, which wouldn't have specified sort of what theory of assault and battery of a police officer. Perhaps we do that now, but we definitely didn't do it then to specify the reason. So I think it's just a lapse of time. And I think the problem—
Wouldn't the police report have been in the file?
The police report, yes. And in fact, consistent with Mora, the Commonwealth had the option of either presenting just the police report or calling the officer to testify about what happened. Both of those options are available under Commonwealth versus Mora. And the Commonwealth chose to put the officer on, which I would suggest actually allows the defendant greater latitude in arguments that they could have made because they would have cross-examined or had the opportunity to cross-examine about the facts as compared to just the police report. So in these circumstances, I would argue that while I think that Perez describes it as more difficult than it actually is, I think even under Perez, if the court looks at that case and the existing case law, Commonwealth did present sufficient evidence. It was a reasonable inference based on the entirety of the facts of this case that the defendant committed a harmful, intentional assault and battery on a police officer. So I just want to move next to the ineffective assistance of counsel argument regarding sentencing. As the court has already acknowledged, the defendant received the minimum sentence. So assuming for the sake of argument that counsel was ineffective just generally with not providing some mitigating circumstances, they cannot satisfy the second prong of FABIAN. They cannot satisfy that they would have received a different sentence. He received every potential benefit that he could have received, concurrent across all counts, concurrent with the other sentence, and receiving the appropriate jail credits. Which really gets to the Commonwealth's perspective on the jail credits, is that the motion judge correctly found that it wouldn't have been appropriate to consider these mitigating circumstances for those jail credits. And I think that what the defendant argues—
It wouldn't have been appropriate, but it wouldn't have been ultra vires, right? I mean, the judge had the authority. It would have been an extraordinary disposition.
I actually disagree with that. I think that what the SJC is these are the two guiding principles, even absent the statutory scheme that exists, and they include avoiding the defendant serving dead time and avoiding double credit. Those are the two guiding principles. That is what we mean when we talk about special consideration of fairness under Blakey and Barton, and even further when there is no statute. So, for example, I don't cite it in my brief, but Commonwealth versus Frias, which is 53 Mass Appellate Court 488. It's a 2002 decision, and it talks about awarding credits for a defendant who was extradited from another state to face Massachusetts charges. And there are a lot of cases in that particular case that talk about, again, fundamental fairness, and it's about fairness to the prisoner. It's about ensuring they get credits for what they're deserved. And in that case, they sort of analyzed when should someone get credits if they fight extradition, when should they get credits if they waive extradition. Those are sort of some of the issues that are grappled with in Fritz. But you'll never see, and I would argue it's an abuse of discretion, to consider completely unrelated considerations like the defendant's childhood and mitigating circumstances, which are relevant to general sentencing, but they're not relevant to the question of whether to use the extraordinary remedy of a nunc-pro-tunc discretionary sentence to award jail credits. So I think what I would say on that point is that the defendant's reply brief with Leiden is just missing the mark. What happened in Leiden is that the judge didn't even realize they had the discretion. And again, the entire argument in Leiden, when you go through it, is about how the defendant's not entitled to the jail credits. They can make an argument about discretionary jail credits, but that's going to have to be handled below. And none of it is about the defendant's personal circumstances, mitigating circumstances at the time of the crime, anything that would normally be related to generalized sentencing. So I don't think Leiden stands for the proposition. They cite it in its reply brief. I think it stands for the proposition that if this judge didn't know they had the discretion, then it should have been remanded back so that they could make a decision about whether to use their discretion. But in this case, it's very clear that the judge knew that she had the discretion and she chose not to exercise it correctly. I think alternatively, I'd just say, if the option is that the defendant can present anything and suggest that it can get this nunc-pro-tunc sentence, then what would be the standard for determining whether the judge abused their discretion in giving this extraordinary sentence? I mean, essentially, there would be no standard to review for abuse of discretion. I think the SJC's told us what the standard is.
Actually, that was my concern. If you can nunc-pro-tunc something so far back in time, that would undermine the mandatory sentence, wouldn't it?
Correct, and I think the judge actually recognized that in the sentencing hearing, that while 10 years is a long time, this is what the legislature has set as a mandatory minimum sentence. If a judge is allowed to say, I understand the defendant had a rough childhood, I understand the defendant's been in and out of custody for the last 5 or 6 years on other offenses, I think the defendant should serve 5 years. I'm going to make this nunc-pro-tunc all the way back 5 years ago. That's clearly an abuse of discretion under the standard. And I think the standard is clear that when you're considering fairness, making sure the defendant doesn't receive dead time, and the cases talk about someone who's been acquitted on an unrelated offense and served 9 months, and whether or not it's appropriate for the court in its discretion to give credit in that scenario. And so these are, there is no case that suggests what the defendant is positing, that you should consider this. And in fact, I would argue it's an abuse of discretion. So again, we're left with, they would have received no benefit from making the argument, that there really is nothing that could have changed about the sentence. And for that reason, they can't satisfy the second prong of FABIAN. So if there are no further questions, I would just yield the rest of my time to my brief. Thank you.
Thank you. Our next case is case number 2022 P748, the Commonwealth versus Fabian M. Gonzalez. And just a reminder that this case is partially impounded.
Good morning. May it please the court, Amy Codignon on behalf of Mr. Fabian Gonzalez. I'm asking that this court vacate Mr. Gonzalez's conviction for insufficient evidence and also, given the cumulative errors that occurred at his trial, to remand for a new trial. Before I begin my argument, I just want to alert the court that there is a Godardo issue here, which was decided after the briefing. It's my intention to seek leave to file a supplement or supplemental briefing once that issue is settled with the SJC, and I just wanted to alert the panel to that issue today.
Sorry, I missed what...
He does have a firearm conviction, which would relate to the Commonwealth versus Godardo case.
Okay.
The two issues that I'd like to focus this court on today, I understand that there are a number of issues in the brief. If the court would like to direct me elsewhere, please do so. But I'd like to focus on the sufficiency of the evidence first, and then second, to discuss some of the issues with regard to Sergeant Detective Stratton and his repeated overstepping in sort of a non-responsive manner and how that affects sort of the justice in this case.
Let me just ask you this from the outset. Do you concede that the government can prove their case by circumstantial evidence only?
I think that there are cases in which circumstantial evidence could be sufficient. I don't think that that's the case here.
I understand.
I'm asking that this court reverse Mr. Gonzalez's conviction because here the only evidence of identification is a fingerprint on a truck that is suspected but not confirmed to have been used in a shooting, and grainy surveillance video that adds nothing to whether or not he is the person involved in the shooting.
But wasn't it the defendant's truck?
It wasn't the defendant's truck. It was a rental car that was rented with Mr. Gonzalez's name. There was no proof actually produced at trial that he was the one that rented it. There were 7 different people whose prints were found on that truck and 23 prints that were unidentified to anybody.
But that rental would be enough to tie him to the truck. In other words, you don't necessarily need the print, right?
Sure, if that was the truck used in the shooting, which wasn't proven.
Okay.
So the evidence here is that there was a white 4-door pickup truck that was involved, that took the shooter from the scene of the crime. The only eyewitness...
Or truck.
It's a similar truck.
Inferably the same truck.
Possibly inferably the same
Observed,
truck.
Inferably, permissibly inferably. For this purpose, you're not asking us to overrule Lattimore, I take it.
No, I'm not. But
So let me just
Sure.
lay down as a premise that a rational jury could permissibly infer that the same truck was present in this same area a week before, correct?
Well, it was in the Roxbury area, not in...
A person fitting the general description of the defendant.
Yes.
Okay. So, just to go back, we are not dealing with a situation where the only evidence of identification was a single fingerprint found on a truck with multiple other persons' fingerprints. There is other evidence that corroborates his connection to the truck, the rental contract, the presence of the truck with a person fitting his description in the same vicinity.
In the Roxbury area on July 22nd, and this is an August 3rd shooting.
But wouldn't you agree the print alone doesn't do it? Because if he has a rental agreement, a lawful rental agreement for the truck, you'd expect to find his prints in and on the truck, whether they're the driver's side, which they were found,
Right.
or whether they're the passenger side, maybe he's putting something in and out of the truck, whether they're outside or inside.
Right.
So the print alone's not doing it. You seem to rely, say, the print is what does it.
Well-
but I'm not convinced.
So I'm not convinced either, Your Honor, and I think that's the point. The Commonwealth concedes that the surveillance video isn't sufficient to identify him. And I think if this court, I asked that the video exhibit itself be transmitted to the court. There's a still image of it within the briefing. It shows very little. It's a very grainy surveillance video. It shows a male person who is lighter skinned
seen
with
it.
dark hair. The eyewitness descriptions of this person are white, black, Hispanic, dark skin. They are 5'8" to 5'9", he's 5'10", 185 pounds, he's 230 to 250. So that doesn't do
No
it.
one fragment of evidence standing alone is sufficient, but that's the nature of a circumstantial case.
Well, it is, Your Honor, but here, this circumstantial case, in order to convict Mr. Gonzalez, requires the piling of inferences. So we need to infer that this is the truck. We need to infer that this print was placed during the time of the shooting, and we need to infer that he was the shooter. And here, that's the impermissible piling of inferences. We don't have proof that this was the truck. The only description of the truck was it's a Ford F-150. This is a Chevy Silverado. So it's found within a mile of the shooting, parked not suspiciously. It's parked along the curb. The officer feels the truck on an August day. It's cold. It hasn't been recently run. It's within an hour of the shooting. So the proof that it's the truck is an inference.
Was the surveillance video, did it depict the white T-shirt in the bed of the truck?
That's what Sergeant
At the
Detective
time of
Stratton
the
would tell you.
shooting?
It's, again, grainy, and you can see a white item in it, and it's not the
And
truck.
then when they found the truck...
Well, I apologize, Your Honor. It's not the truck as it's leaving the scene. It is a white truck traveling down Homestead Street at a certain point, but this is not, the shooting does not happen on Homestead Street. So they do capture a white truck with an item in the bed of the truck. But whether or not it's the same truck.
Around the time of the shooting.
Around the time of the shooting. But whether or not it's the same truck, again, an inference.
I understand. But, and then when they found the truck, a mile and a half away from the scene, or whatever it was, in a short time frame after the shooting, there was a white T-shirt in the bed of the truck.
There was. Yes.
So that's one piece of circumstantial evidence.
Again, in order to add all of this together is the impermissible piling of inferences. And one thing that I would like to suggest as I transition, unless the court has questions on that, as to Sergeant Detective Stratton's testimony, the evidence that he gives as to identification, as to the significance of the fingerprint evidence, that is not competent evidence that this court should weigh in terms of whether or not the evidence is sufficient.
Well, trial counsel would agree with you, and trial counsel, in fact, used that premise fairly effectively to create what I would consider a fairly devastating line of cross-examination, discrediting the officer's testimony. By the time he was finished, the jury would have applied a great deal of skepticism, I would think, to everything that the officer had said on the witness stand.
Well, I disagree with that, Your Honor, because we're here.
Well, it's okay, we don't have to agree.
Sure, but so the idea that it was helpful to counsel to elicit identification evidence in a case where there is none, just so that he can effectively impeach it, is
He didn't
absurd
elicit it.
to me.
He didn't control, at least for that purpose, what the detective's answer was going to be. However, the detective gave an answer that rather plainly overstated what any person seeing the video, including the jury, would believe could permissibly be drawn from that video. And so rather than moving to strike the answer and therefore go no further with it, he proceeded to dismantle the officer's credibility to a fare thee well.
Well, Your Honor, again, I disagree with that because
We can
this
disagree.
defendant was convicted.
Works out
but
better
the
for you,
issue,
by the way, when we get to the end of this, if we are no longer in disagreement.
The issue here, though, is that Sergeant Detective Stratton's opinion, Your Honor, states that obviously nobody can see that this is the defendant, but that's not what he said. He said, I watched this video over and over and over again on my monitor at my office, and the quality there is much better than you're seeing here. And that's how I know that this is Fabian Gonzalez. He says it 4 separate times that he can identify Fabian Gonzalez as the person in that video after watching it on his special monitor.
Yeah, but here's the problem, though. When a witness starts to, run on at the mouth like that, it's a little bit difficult to unring the bell when the jury's heard that. So the lawyer's faced with a decision. What do? Do I ask that something like that be stricken, which could raise some questions in jurors' minds? Oh, why are you doing that? Or do I go with it and continue with my theme that this officer is biased and he made up his mind from the beginning that the defendant was the perpetrator, and every step he took was aimed at getting this defendant and not looking at other possible suspects? And that's exactly what he did.
He did. And perhaps on the first instance, that makes sense, right? But this happens 4 separate times. And the other piece of that is that counsel admitted at the evidentiary hearing he didn't actually even consider moving to strike. He didn't consider curative instructions. He didn't consider moving for a mistrial. He didn't consider any remedy for the defendant. He just went right ahead because, as he said, he was on his heels. And maybe it makes sense on the first time that an identification is volunteered, but when it's a second time, and a third time, and a fourth time, at some point, the judge, we should be asking that the judge instruct this witness to stop volunteering inadmissible evidence. The Commonwealth concedes this has no place before the jury.
But if at every time he's offering the evidence and the defense attorney is able to show the weaknesses of the evidence, he asks him, okay, so what can't we see on this monitor that you could see on your fancy screen back in your office, he asks them, and no sufficient answers. And so by repeatedly doing that, doesn't he put forth to the jury that you can't rely on anything you say?
I don't think so. And again, because we are here, because the jury convicted on a case that was so circumstantial, where there is really very little proof that this individual was Fabian Gonzalez as opposed to any other individual in the city of Boston. And it's not just the identification, it's the significance of the fingerprint evidence. He says to the jury, I know that that print was left here during the commission of the crime, which is an element that the Commonwealth needs to prove to convict Mr. Gonzalez. And he says so based upon no expertise. It's a completely inadmissible evidence.
Was that at odds with the expert that the Commonwealth did offer?
Yes, because that expert never went there. So in that sense, it's at odds. The expert says, I can't tell when a print was left. I can't date it. Sometimes people touch things and don't leave a print. All things that are actually accurate.
The jury had that evidence in front of them from the expert.
Right.
And then they had this officer who, the phrase "talking out of his hat" comes to mind, especially after defense counsel was finished with him on cross.
Well, and that may well be true, but the case law throughout the Commonwealth recognizes.
I hope it's true. I try not to say things that are untrue.
Well, but the case law recognizes that jurors believe police officers, especially somebody like Sergeant Detective Stratton, who has decades of experience as a homicide detective, and it talks about his experience with investigation, why he chose to do certain things, why he chose not to do certain things, and he is throughout this trial just injecting things that have no place before the jury. He's telling the jury he believes, 2 separate times, that he believes that Mr. Gonzalez is guilty.
And in a case where defense counsel's strategy, among other things, was a Bowden defense, suggesting that the police conducted an inadequate investigation without permissible basis. They seized immediately on this guy as their suspect, went there despite alternative possibilities that they neglected to explore, and now he's taking this guy's certainty and turning it back against him over and over and over again. It didn't work. It didn't work, but that is not effective assistance standing alone.
It was not his strategy, and I think that that's the point. He didn't intend for this information to be before the court, and whether you're introducing a Bowden defense or not introducing that type of defense, that doesn't mean that the officer can opine on guilt. The case law is clear on that, and he does that by way of identification. He does that by saying that all leads lead to Mr. Gonzalez. He does it repeatedly. There's the Wadsworth case that he violated that. There's the Lodge case that he violated that.
The motion judge, though, said it was his strategy, even though counsel attempted to fall on his sword. The judge wasn't buying it, and he said it's clear that from the judge's opinion that he gave a very careful look at the evidence in the case, and he said there is a clear defense strategy here that was underway, despite counsel's protests that he didn't have such a strategy.
I think what the judge ignores, though, is that the information, the questions that were asked were in line with his strategy. I have no issue with that. But the answers that were received were non-responsive to the questions that were posed. These are yes or no questions, and they're eliciting identifications. And the court seems to apply too broad of a brush and sort of ignore that he didn't want this information before the jury. And sure, he reacts to it consistent with his strategy, but whether or not he was trying to elicit identification evidence in a case with no identification, that was not his strategy. I think that that's a clearly erroneous finding of fact. And I'm asking that this court not credit those findings, because counsel testified to it. But also, if you look, when the Commonwealth asks the same question on recross, he objects. He doesn't want this information before the jury, and why would he? It's highly damaging to his case. I don't want to start on a new issue, but if the court has any additional questions, there are a whole host of issues here, and I think my point is that the cumulative error from sort of the start to finish of this case, there are errors throughout from the jury impanelment to a sleeping juror to a juror contamination issue, and I'm asking that the court consider those issues in the cumulative as well.
Thank you.
Thank you.
For the Commonwealth?
Good morning, Your Honors. May it please the Court, Elizabeth Martino on behalf of the Commonwealth, asking that the Court affirm the defendant's convictions. I wasn't going to spend too much time on sufficiency because I think it's addressed enough in the Commonwealth's brief, unless the Court has any questions on the issue of sufficiency. This was a circumstantial case, but I think I lay out in the brief the different facts that came out at trial that, when added up with the inferences in the light most favorable to the Commonwealth, to establish.
Strongest case.
It's a circumstantial case for sure, but I think that the sufficiency is certainly here. That with the inferences in the light most favorable to the Commonwealth, do show beyond a reasonable doubt that the defendant was the shooter. It's very different from the Morris case, which is just the fingerprint on the clown mask. Here, there's the rental truck of the defendant seen in the area, the weeks prior to the shooting. The right before the shooting, the rental truck is caught on surveillance video with the T-shirt in the back, and then
A truck of the same color. I mean, how many white pickup trucks are there in the city of Boston?
sure, there's probably plenty, but I think the inference here is it is in this area with the same dirty white T-shirt in the bed of the truck that's visible in the surveillance video. It's right before the shooting, and then that is found, you know, a mile away or a mile and a half away, possibly shortly after the shooting as well. The, you know, same make model, and it's the defendant's truck, and then somebody in a video is seen, you know, similar height, weight, hairline to the defendant. And then there's also the Facebook post by Shaquille Burden, whose fingerprints were also found in the truck. And the Facebook post says, you know, basically says, we did this, or I did the shooting, and next time we'll get him. So there's a lot of evidence here when added up that does establish beyond a reasonable doubt that it was the defendant who did the shooting. So I think
The Facebook posts doesn't say we did the shooting, for sure. And I don't even think it says I did the shooting. It just says next time I won't miss.
Right.
Right?
Right. So I think, again, in the light most favorable to the Commonwealth, considering that Mr. Burden's fingerprints were also in the truck, and that he then, you know, posted that on Facebook, saying, I think it was POBEDA, I have to double check, it's in the brief.
But if that's strong evidence, why didn't you arrest Burden?
Claiming responsibility for the shooting. Well, Burden's fingerprints were on the driver's side. He wasn't consistent with, you know, his hair is long and in braids, and not consistent with the person who actually did the shooting on the video. Perhaps a joint venturer, but he wasn't arrested in connection with the crime. But certainly, you know.
I know he wasn't. I was asking why.
Yeah. It's not in the record, Your Honor. So anyway, that is the sufficiency, I think, much more than in Morris, and I'd rest on my brief, you know, beyond anything unless the court has questions. Moving on to the other alleged errors, I think it's important to place the defendant's claims in context here, which is that these are not evidentiary issues in the Commonwealth's case in chief, like the, you know, video identification and the identification of the truck. These were pieces of evidence elicited on cross-examination, and the issue before this court is whether it was ineffective of trial counsel.
Cross-examination during the Commonwealth's case in chief, right?
Yes, Your Honor. So, but it is not the problem. So just starting, for example, with the video identification. The Wadsworth case, which is the seminal case on which the defendant relies for saying that this was improper, is a case where the Commonwealth introduced a video identification in its case in chief. What the SJC said was incorrect about that was the impromptu of authority in having 4 police officers testify with a slowed down video over and over again about the, you know, similarities, and these 4 officers saying, I think it's the defendant in the video, and then having the prosecutor argue in closing, you can rely on these officers who've watched this so many times.
I'm a little confused, because had the defense counsel not proceeded to discredit the officer and left this answer standing alone, that would have been troublesome, despite the fact that it was elicited spontaneously in response to a question on cross-examination and not by a question from the trial prosecutor, right?
It may have been.
And had defense counsel sought an order striking the testimony, striking the answer at the time that the answer was provided, that likely would have been allowed.
It may have been, or the prosecutor.
So the imprimatur issue is present whether or not it's elicited in questioning by the prosecutor or in response to a question by the defense attorney.
Well, if I may, Your Honor, I would actually follow up and say, if we're following with your hypothetical, the defense attorney says, I object, I'd like to be heard at sidebar, I want to move to strike that testimony from Detective Stratton. The prosecutor could have said, well, Your Honor, this is a rebuttal to Bowden a Bowden defense. At this juncture, I did not introduce anything in my case in chief about an identification of the defendant as the person in the video, because I didn't think that I could do that. It's up to the jury to make that connection. But since his opening, the defense counsel has launched a Bowden defense, a vigorous defense, saying that all these other people could have been the shooter. I think my officer is allowed to say, in a limited fashion here, that based on height, weight, hairline, the defendant's characteristics are similar. That could have been a proper Bowden rebuttal at this juncture.
That was not the officer's answer. That was not the officer's testimony. His testimony expressed a much higher level of certainty that specifically said that this is the guy.
Without quibbling exactly about the facts, I just point out that this may have been, had there been an objection,
we don't need to quarrel about
right.
a request to strike that didn't.
Right, exactly. But so I think certainly counsel was effective here in moving on, in neutralizing, in using the answer to say, come on, Detective Stratton. I mean, you're saying that you can say it's the defendant in this video and nobody else can say it's the defendant. So as your honors have already pointed out. But that is not to say that it certainly would have been this inadmissible evidence had there been an objection, had there been a motion to strike. The prosecutor could have said, and may have been successful in saying, we've got a vigorous Bowden defense here, Your Honor, and this is the type of limited rebuttal that's permissible. So I think in the context, this is not the Commonwealth introducing in its case in chief, the Commonwealth using it as an impromptu of authority, the Wadsworth things that are not admissible. This was elicited on cross-examination. Cross-examination is fraught. You're not always sure the answer you're going to get. And in this case, where the whole defense was this vigorous attack on the police investigation, the officer's like, this is why I did what I did. This is why we did what we did. We thought that it looked like the defendant in that video.
So at the end of the day, though, the court declined to give a Bowden instruction, is that right?
Well, I don't think a Bowden instruction was actually requested. I'll have to check. But a lot of the Bowden instructions and limiting instructions are about hearsay evidence that gets in for no other purpose except to show sort of like, why the police did something. And none of that evidence was admitted here. There were no limiting instructions needed on any type of hearsay evidence. It was more like there were things that, like the booking photos were admitted in part as Bowden rebuttal evidence.
Let me ask you about that.
Limiting instruction.
Let me ask you about the booking photos, because there seemed to be a lot of testimony about how the defendant appeared in prior booking photos, and I believe the officer even referred to them as booking photos at one point. I believe he also referred to a prior arrest in connection with the booking photo, didn't he? Now, I don't recall seeing you respond to that in the, I know there were a lot of issues raised, there were like 29 issues raised in this case, but how do you respond to that argument by the defense that that was something that was prejudicial, that there was a passing reference to a prior arrest?
Right, it was a passing reference to a prior arrest. The judge said to the prosecutor, did you instruct your witness not to testify like that? And she said, I did, Your Honor. I'll make sure to lead him to make sure that he doesn't do it again. There was no limiting instruction or curative instruction asked for by defense counsel, and it was sort of a fleeting thing. In terms of whether the underlying hearsay evidence in the booking photos was admissible, again, there was no real back and forth about why they were admissible. Everybody agreed the information on the booking photos was sort of hearsay, but had there been an objection, it would have been futile because it would have been admissible as, again, Bowden rebuttal evidence to show that the defendant was arguing all these other people could have been responsible for the murder, and it was just limited non-prejudicial evidence to show why the police did not follow up with all of those leads of the other people whose fingerprints were on the cars and rather chose to focus on the defendant. And the defense counsel actually used the hearsay biographical information that was contained in the booking photos to launch his third-party culprit defense. He used the hearsay evidence contained in the book and photos of Odalyn Cruz to say, here's somebody who's the same size, weight, shape, hairline, and yet you didn't arrest, and whose fingerprints were in the car, and yet you didn't arrest him.
But you would agree that that's not something an officer with no personal knowledge of should typically be testifying to, right? As far as like what someone weighed 10 years ago when they were booked on another offense. He should have been testifying to that.
This is something that probably should have been better hashed out in like a motion in limine, and the reason should have been put on the record. But again, when we're looking at ineffective assistance of counsel, we're looking at whether an objection would have been futile, and here it would have been, because it would have been overruled, because this is all proper rebuttal testimony, Bowden testimony, and also it didn't deprive the defendant of an otherwise available defense. He used this evidence to his advantage as part of his defense. Similarly, just going back to, the video, again, as I've already explained and in my brief, it was not the case in chief. The identification of the truck, I think, was not an identification of a truck, and identification is not something that is used. The Wadsworth was about the defendant, not, pointing out similarities between a truck and a surveillance video, and the defendant's truck that was found at the scene is proper. The sleeping juror, I did want to address quickly, if the court would allow.
Yes, I'd like to hear about that.
Yeah, so that actually is an issue. And at the end of, towards the end of the trial, right before deliberations, the prosecutor mentioned to the court, this is at trials, volume 7, 219 through 221, I think that there's been a juror that may have been sleeping. And the defense counsel says, oh yeah, my client mentioned that too. And
A couple of times.
A couple times, Your Honor, yes. And the judge says, well, what am I supposed to do about it now? And I think the law is clear that if a judge...
Hold on, the judge says, no, I didn't see him sleeping.
Thank you, Your Honor. Very important, yes. The judge says, I haven't seen it, I've been watching, I haven't seen it, and what do I do now? The law is clear that a judge, when he's brought a credible, reliable report about a sleeping juror, must do further inquiry. So I think the real issue here is whether the judge properly found that there was no reliable, credible report. And I want to...
Based on not one, but two reports from both sides.
So, right, and I think it is important to look closely at the record here I think the record does support that the judge did not abuse his discretion in finding that it was not a reliable report requiring further inquiry of the juror. And that is because the prosecutor said, I don't really look at the jurors, but today I did, right, during closing, which is not evidence. And then the defense attorney said, my client mentioned it a couple times. But the judge said, I haven't seen it, and I've been looking, which is important, and may have, and I think the record bears out, found that the defense counsel didn't ask for a voir dire. He's saying, my client has said it a couple times, but if you had really believed your client, wouldn't you have said something to me here earlier? And the prosecutor saying, I don't really look at the jury until today, during closing. I think those facts altogether do show that the judge did not abuse his discretion in finding, based on his own observations and those limited my client said it a couple times, I don't really look at the jury, but I did today. He did not abuse his discretion in finding that that was not a reliable report.
So I'm just going to push back because, for one, he says, I looked at him today specifically to see, essentially the inference is to see if he was sleeping, to pay attention to see if this was really happening. And oftentimes it's not what the judge says, it's but how he says it. So if the judge says to you, listen, I didn't see it, what are the lawyers to do?
Well, I think this is, again, the record is what the record is. My argument is that the judge said, I've been looking, I haven't seen it. Right? And that's not dispositive, and the cases do say the judge doesn't have to see it, it has to be a reliable report. But the judge is saying here, I've been looking, I haven't seen it.
Does that make it an unreliable report?
I think his point is, I don't find this credible enough the defense counsel merely saying, my client said it a couple times, but never having brought it to the judge's attention before, and never and not asking for a voir dire at the moment, I think the judge could discredit that. Oh yeah, now that you bring it up, my client said he's seen it a couple times. You see, the record bears that out, that the judge could say, I don't find that credible, and also the prosecutor expressly saying, I don't really look at the jury, but today I did, and today, I thought I saw the juror sleeping, but that was on the day of closings, which aren't evidence.
Didn't the judge also reason that had it happened, they would have reported it immediately to defense counsel, who would have immediately brought it to the court's attention, and that didn't happen?
Yes, Your Honor. I think that is an appropriate inference from the record. So I think based on the facts in the record, it is a permissible and appropriate inference that the judge did not find the reports given to him at the time credible and serious enough to do a voir dire, and I think he did not abuse his discretion by so finding. In such a case, he did not have to do a voir dire. The cases that find a voir dire was necessary are ones where, like, a juror comes and says, this guy's been snoring through the whole trial. But the defense counsel kind of jumping in at the end and being like, oh yeah, my client said it a couple times. The prosecutor saying, I haven't really noticed it till the end. And the judge saying, I haven't seen it.
We're well over.
Thank you, Your Honor.
Thank you. The next case on our hearing list is case number 2022 P1154, POBEDA RT2 LLC versus Michael Brangwin and others.
May I proceed?
May.
Good morning, Michael Ford. May it please the court, representing POBEDA RT2 LLC. This is the property that's being developed into the high-end, low-density residence that's 240 feet away from this proposed biotech R&D property, one in which the special permit was actually modified from a 33,000 square foot normal business hour neighborhood supermarket to this 88,000 square foot 24/7 operation with everything that goes along with this type of operation.
24/7?
24/7 for the biotech, yes.
You say
So-
24/7, I'm not sure I follow.
Oh, 24
Are you
hours.
suggesting that, let's say, for example, the lights will be on 24/7?
Lights will be on 24.
That's not the evidence, though, right?
But I think you have the evidence of Peter Zagorianakis, who is providing the facts for which was relied upon in part by the appraiser.
No, the judge rejected it.
Specific to this lab, right?
Rejected the lights alone.
No, but said that there was no indication that that was in fact going to be the use at this facility.
On this, with respect to the, I would say that would be within the lights and the claim of harm relating
The claim
to
of
lights.
harm rested on the assertion that this operation would be conducted 24/7, but there was no indication, no evidence that established that that would in fact be the case.
And what I would suggest, just as to that point, would be any facts that Mr. Zagorianakis was able to put into the record at the trial court. Getting back to the presumption, I know this court knows the presumption, especially the Chief Justice. With respect to this,
All three of the justices are familiar with the law.
Familiar, but I know that I'm from appearing before you before as the land court. I tread.
A long time ago in a
tread
galaxy
lightly.
far, far away.
I tread lightly. Anyways, there's a presumption of standing. It's in a abutting property. The burden switches, and they have to provide the evidence, offering facts or providing affirmatively showing that POBEDA has no reasonable expectation of proving the harm. They didn't do that in this particular case, and this just goes to the fatal flaw that Spooner places out there that sets the law. All that they had was a dismissive claim with just a quote to the law. And as we'll get into it on the zoning code, and I understand in their brief, they challenge the purpose of conserving the value of land and buildings as set forth in Kenner.
The diminution of value, is that the argument you're?
So, yeah, I'll get to the diminution of value, but of course, their argument, and we believe this is the case, that it must be tethered to something that is protected in the zoning code. In this zoning code, section 1.00A, encouraging the most appropriate use of land. That's the essence of a special permit. Section 1.00G, reducing hazards from other dangers. And what is really important is, as you look in the appellee's brief in Kenner, at their brief at page 22, they don't really address those other two items that I just called to the attention of the court. And more importantly here, they focus just on Standwick, which is the diminution of value has to be derivative of the related cognizable interests and protected.
Isn't that what Kenner says? Wasn't the same language in Kenner v. Chatham?
That's what was in Kenner and Standwick. But there was something right stacked in between those quotes, and one of those quotes was from, if I'm pronouncing it correctly, Tranfaglia, that it's not designed for the preservation of economic value except insofar as that end is served, making the community a safe and healthy place to win. I believe that's on pages 171 to 173 of the Kenner case. But bringing it back just to the presumption, before I go to the diminution, they've failed to rebut this particular item. And what's important in Spooner is that POBEDA has no obligation to produce any affidavit at all at this point in juncture, and we only need to satisfy one element.
But I think the point, under both Standwick and, which is a 40B case, and Kenner, is that the presumption applies to those legally cognizable interests. And to the extent that preservation of value is not among those, it doesn't matter, right? Isn't that the argument?
That's their argument, but my argument goes to the appropriate use of land, which is that first part in the Watertown zoning code. And
well, is there a zoning bylaw or ordinance in the Commonwealth that doesn't include similar phrasing?
I'm sorry, once more, Your Honor?
Is there a zoning bylaw or ordinance in the Commonwealth that doesn't include similar phrasing?
I would say similar, but has it been addressed?
Well, what about Chatham? Let's because we do have some guidance that flows from Chatham.
But Chatham, if it's read, is focused on the conserving the value of land and building element. Doesn't address completely the other items that are protected by the zoning code. If I may just move into the diminution of value, which they say this should not be considered. This was an appropriate affidavit. This was an appropriate analysis for a licensed, experienced real estate appraiser. He did the analysis, put it out there of external obsolescence as well as negative influencing factors, which would be part of his analysis in determining whether or not there's an impact on the actual value. And the burden that we had at that point at the trial court is a plausible claim of injury. And his job, Mr. Harji's job, was justifying a reduction in the value in the eyes of a competent, experienced appraiser. And this was after, as you know, after looking at the substantial description of the project, the property in the neighborhood, the orientation, and Cressett's plans. And he just concluded this will have a negative element. It would provide for me to value the property less. This was a market analysis, not an appraisal, not required at this stage. The other things that he did do, which is permissible, he relied upon otherwise admissible facts. Mr. Zagorianakis, a property owner, providing facts, review of his properties. He's well experienced in the biolab R&D world. He owns a biolab and a developer of future biolabs. You would expect him to know these factors and elements, and he goes on with a list of items about 24-hour operation, complaints of neighbors, biohazardous use. That's the very essence of a biolab property. And then he relied upon Mr. Bennett, I know, with respect to lighting, but that was one other element to the factors of value. And again, Crescent, they could have rebutted. They didn't do it. Yes, they moved to strike, but unfortunately, that's not in front of the court at this point. The news articles, they try to make a lot of hay with the use of news articles. You have it in the record. Affidavit appraisers routinely consult them to inform themselves of market analysis, coupled with those other facts. And these articles showed an overwhelming evidence of negative externalities with respect to a biolab use. Finally, again, just getting to it, this was a market analysis showing that the nature of the changes will provide a substantial difference, that they will be negative, thus supporting the evidence that there will be a negative effect on value. And with that, if there's no further questions, I would rest on my brief.
I have a question for you. This, and neither party cited this case, but this case came to mind when I read the briefs. I don't know if you recall it, but it was the Belmont Temple case, Martin versus the Corporation of Providing Bishop Church of Jesus Christ of Latter-day Saints. And in that case, there was a steeple that the church wanted to construct, and some neighbors were upset about it and the impact it would have on their property. And it was ultimately resolved on a First Amendment issue. But before the court got to that, the court did address standing for similar reasons. And the issue was, well, is, you know, the visual impact of the steeple, and especially at night when the steeple is lit up and would cast light on neighboring properties. And in that court, the SJC said that is sufficient for standing, provided that impact is connected somehow to the zoning bylaws. And in that case it was, because the zoning bylaws required the zoning board to take into account visual consequences. So what, putting aside the value question, what in the zoning bylaws do you believe addresses the very issue that you're complaining of now, as far as light goes?
I believe it's the first one in the brief, that was encouraging the most appropriate use of the land, 2, reducing hazards from other dangers, and that it's in the Trigvalia case.
Okay.
Thank you.
Thank you, Your Honor.
For the defendants?
Good morning, Your Honor. Mark
Afternoon,
Bobrowski
Mr.
for the private defendant, Crescent Ventures. I'll just refer to them as Crescent, if that's all right with the court. Just before I lose track of your question, Your Honor, and your question as well, Mr. Chief Justice, the Chatham bylaw does contain all 3 of the purposes cited by the brief of the plaintiff appellant. If you take a look at the appendix that I offered, which is the 2022 Chatham zoning bylaw, on page 52 of my brief, my opposition, those 3 elements, which include encouraging the most appropriate use of land, conserving the value of land and buildings, and reducing hazard from other dangers, are all in the Chatham bylaw when Kenner was decided in 2012, as well as in the current Chatham bylaw in 2022. And that leads me to a point. Many bylaws have these clauses in them, specifically because the uncodified Section 2A in Chapter 40A, as we know it today, has a list of suggested purposes, and these are in there. So many communities have simply incorporated that uncodified section into their purpose clause in the local bylaw. And
Watertown has done the same?
say it again?
Watertown has done the same?
I don't know that Watertown goes that far, but they do
that
say
effect.
conserving the value of land.
So in that case, how do we square Kenner's rejection of value as a protected interest with the language of the Chatham bylaw?
Kenner's the final word. When the Kenner case was argued, the SJC was well aware that preservation of value of land was in the Chatham bylaw. It was cited in the brief of Kenner, and I provided that excerpt to you. I believe it's
Yeah, but it wasn't addressed in the opinion.
well, it
In fact,
was.
the opinion appears to rest on a premise that is belied by the record.
I think the SJC got it right. They did say very clearly on
We're
page.
bound to agree with you.
They did say very definitely on page 123, 124 that and to untether a claimed diminution in real estate values from an interest in the zoning scheme seeks to protect would permit any abutter who claims that any change in property would diminish the value of property to obtain standing and challenges.
Well, but they also say that in fact, it was untethered in this case, and now you point out that maybe that wasn't quite right.
I would never go against.
But they don't engage that issue. I mean, it's an interesting point of tension, isn't it?
I doubt we're going back because of the slippery slope that the
Get
court
it. Let me
cited.
just for a moment, though, isolate the question as it relates to this topic of value in and of itself. Because in the other areas of contention on appeal, there was expert testimony that rather conclusively belied the impacts that were being claimed as a matter of fact, and that fact was not met with evidence that would suggest that that they were wrong for summary judgment purposes. Here, on the question of value, the motion judge appears to have engaged in a substantive evaluation, a bit of a weighing of the competing evidentiary proffers, which ordinarily is not undertaken on summary judgment, and which I gather is the reason why you're focusing so squarely on the question of whether value is even a permissible interest for purposes of standing.
I agree. The claim of diminution in value was, if I recall correctly, something that came up late in the game, if you will. I can't recall whether it was briefed in the Superior Court papers. But
I mean, Mr. Ford alluded to my past life, and back in the day when I was handling these cases, value was routinely considered a part of the underpinnings of a cognizable legal interest.
Yes.
That's, after all, what a lot of people care about when they own property.
I agree. But having hit 4 home runs in the summary judgment motion with regard to traffic, noise, air quality, and lights, there is nothing to tether the value to.
This goes to the question I was asking before. As I read the zoning bylaws, there is a requirement that for site plan review, which the zoning board is supposed to take into account as well, and this is section 9.03 C10, that the proposed development shall protect abutting properties from detrimental site characteristics resulting from the proposed use, including, it lists a number of things, including lights or visually offensive structures or site features. Isn't that enough to tether the value question to the zoning, to a specific provision in the zoning bylaws to allow standing?
We supplied credible evidence through an expert that produced a photometric plan that there would be no overspill or glare from the Crescent property onto the Pobeda properties. And that was uncontroverted. All we had was speculation that if it was a 24/7 facility, there's no evidence in the record, by the way, to suggest that it would have a lantern-like effect on neighboring properties. There's a condition in the decision that was rendered by the Watertown Board that if the lights, if the shades remain open, there's a simple solution to that, and that automatic shades, for example, can kick in when darkness sets in. And I believe I cited that in my brief. So in that regard, it's a lot like the two land court cases that I put in one of the, I think it's Appendix 6 and 7, one in Winchester, one in Edgartown, in which conditions on noise require monitoring. And if there's a breach of the protocol suggested in the decision, then things have to come back into compliance. And so I think that's exactly what Watertown did with regard to lights. But there's no evidence, credible or otherwise, presented by them that, A, there will be overspill or glare. You're not entitled to not see the light. You're entitled not to have the light spill over onto your property so that it lights your property. You can see lights at an enormous distance. And there's no evidence whatsoever in the record that they produced. So it's much like what they did with regard to traffic, with regard to noise, and with regard to air quality.
But of course, doesn't all of that tend to go to the merits of the claim? I mean, if we're just here at the threshold of trying to answer whether someone should basically get his or her day in court on a standing issue, we really don't have to go into who should ultimately prevail. So in other words, my concern is this. If we take away the corporate sort of interests involved, and we just have the 80-year-old widow in her homestead, and there's a development going up right next to her, and she's concerned about the lights and so forth, is it enough to defeat her standing to just roll in with a high-paid expert on illumination and so forth, where she's not going to have the resource to do that, to counter that? Is that enough to defeat her standing and not give her her day in court?
I had that case with Judge Piper, Chief Justice of the Land Court, a couple of years ago in Tewksbury. A hospitality company wanted to put a hotel. The literal plaintiff that you just mentioned was across the street. One of the issues was lights. We provided evidence through a photometric plan that there would not be lights that intruded onto her property, and Judge Piper dismissed the case on summary judgment. We had to have a small trial on the issue of traffic.
On summary judgment?
No, he set the trial to go in two directions. One, he could not make a decision on summary judgment on the traffic issue, so he scheduled a trial of the traffic personnel in which he would hear on standing, but he also wanted to hear on the merits so they wouldn't have to call him again. When he heard the merits on traffic, he then resolved the matter on summary judgment. Because
okay, so the standing was just assumed in that case.
Because he had acknowledged that my traffic engineer, my noise consultant, my architect, and my shadow and light consultant all had carried the day.
And what are you familiar, I assume you're familiar with the case I was referring to, the Mormon Temple case?
Yes.
The lighting? It doesn't take much, really, to get standing. You just have to connect it to the zoning bylaws somehow.
But even if it's a locally protected interest, and I think lighting probably is a cognizable zoning-related injury. I don't think it needs to be locally defined. But if you use it as grounds for standing, I think that you have to follow the case law. Quantitative evidence, that is, for every injury you claim, you must produce an expert to rebut the experts involved. And qualitative, that the evidence produced by the expert is the kind a reasonable person would rely on, a reasonable trier of fact, in order to make a decision. That's the standard.
Remember the name of the case? That was Judge McHugh's case in Waltham.
Yes.
I can't remember the name of the case.
That's the standard today. I believe that this all evolved from the Barbanek case in 1992 when Justice Lawrence at this court wrote a very strict decision on standing that sort of changed the landscape. And since then we've seen...
Except for Ashley and put the pendulum back in the other direction after that.
Case after case after case has said the door has to be opened properly in order for a plaintiff, in order to pursue their case. And Marashlian, for that matter, though, says that the decision of the trier of fact on standing should not be disturbed unless it's clearly erroneous. That's the standard that we have in front of you today.
Is this a fact question or a legal question?
Yes, I think it's a question of law and fact.
Law and fact.
Yes. If I could just make sure that I've covered everything I wanted to say to you. Oh, with regard to the affidavit that was submitted on perception of stigma, I think that sets the bar incredibly low for a legally cognizable claim. The examples offered by the expert and cited in the brief by my brother include incidents of releases and resulting infections. There's no evidence in the record of any of that. The second example was bioterrorism. There's nothing here regarding bioterrorism. And the third is the perceptions of those living nearby. That's the issue in every case of standing, for the most part, the perceptions of the neighbors.
The Hodges affidavit?
Say it again?
Which affidavit are you referring to?
That's in the brief, that when he cited the, I forgot the gentleman's name.
Is it Hodges, H-A-R-T-G?
Yes, that's correct.
Yeah.
And on page 19 of the brief, on page 18 of the brief, he cites those examples.
So if they're doing research on respiratory viruses in bats, the neighbors really don't have anything to worry about?
I just think it's speculation, it's hypothesis, it's conjecture. None of that has any real bearing in fact here.
No, but a real estate appraiser can take into account in assessing valuation any number of different factors that may bear on market value, right?
We don't know those factors because they did not give us anything more than a thumbnail sketch of what the appraiser did. He didn't have a valuation at the end of it, that's for sure.
Well, and in any event, as we've already discussed, there was evidence which, if credited, was pulling in both directions and probably would be adequate to survive summary judgment if the underlying question were an appropriate basis to support standing.
Right. If there are no more questions, I'm content to rest on my brief.
Thank you both.
Thank you.
That brings us to the final case on our hearing list this morning. Case number 2022 P1139, ENI 131 Commerce Way LLC versus TL Edwards Inc.
I'm the first to issue a good afternoon, Your Honors. I'm Matthew Furman on behalf of the appellant T.L. Edwards. The open legal issue we are here for is that, and we believe was improperly decided below, is whether the holder of a right of first refusal, here the plaintiff, who is required to exercise its rights on the same terms and conditions under the contract as a bona fide offer, can ever specifically enforce a cash offer the burdened property owner received when they were presented with only a no-cash land swap by a third party. We believe this issue was improperly decided below on Edwards' special motion to dismiss under the lis pendens statute, and we believe such a claim has no basis in Massachusetts law based on the verified complaint with its exhibits.
It's a novel question, isn't it?
It's novel, but it doesn't require you to deviate from the Massachusetts framework that's been set up.
And therefore, for that purpose, the judge, you contend, should have dismissed the action without further proceedings and awarded attorney's fees.
Yes, Your Honor, because it's not a viable claim under Massachusetts.
Why isn't the appropriate avenue to raise that challenge a motion for summary judgment and not the special motion to dismiss?
Because, Your Honor, it is purely legal, which can be considered at that stage.
If there is no merit, but if it's a novel question, a question of first impression, at least in the Commonwealth of Massachusetts, it would require some consideration. It's certainly not frivolous. It's not legally baseless. It's not the sort of thing that warrants the immediate dismissal and award of the sanction of attorney's fees for bringing a claim. The lis pendens statute was designed, the amendments to the lis pendens statute that provided for the special motion to dismiss, was designed to rein in abusive uses of the lis pendens to tie up properties on frivolous claims and to bring a prompt end to those things. This is I have to say, it's an interesting question.
It certainly is, Your Honor, as somebody that's spent a lot of time thinking about it. But I'm reminded of a case that we do cite in our papers, and it's in our addendum because it's unpublished from this court, and it's a Motorella v. Rapp decision from 2021, where the plaintiff made the argument in response to the list pendant special motion to dismiss. Whoa, 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 this claim is not frivolous. It may be novel, but it's advanced in good faith. And this court affirmed the dismissal of that claim under the special motion to dismiss, saying...
You know what we say in that header to our unpublished memorandum of decision, don't you?
I do, Your Honor, but
The reason we say that.
But my point with referencing it is that frivolous is not frivolous, meaning broad in bad faith.
And?
It is the claim viable? It's equivalent to 12b-6, and there's certainly precedent for judges to convert a special motion to dismiss to a 12b-6 finding. The Faneuil Investment Group case is one example, and that was affirmed on appeal. But the court needs to look at whether it's a viable claim. And when a holder runs into court seeking to specifically enforce its right of first refusal, the questions are, was there a bona fide offer? Was there adequate notice? And did the holder validly exercise? And in Massachusetts, valid exercise means strict compliance on the substantially the same terms and conditions. And that's because the SJC has said that ROFRs cannot be used to impede marketability.
But you concede that there was a bona fide offer?
There was a bona fide offer. There's no evidence to the contrary. I'm aware of what the letter agreement would aggregate with what aggregate says, but what I'm focused on is what E&I ran into court seeking, which was just specific performance. If an offer is not bona fide, we know from the Roy case that that means it wasn't triggered in the first place. Okay, so they would not be entitled to specific performance. We know from the Scott and Sudbury cases that if the notice is not adequate, it's not triggered in the first place. But if, I'm sorry, Your Honor.
How'd you come up with 20 million?
How did we come up with 20 million? The evidence in the record below is Mr. Edwards' affidavit saying that it came from aggregate. And it says in the cover letter, which I'm sure you'll hear about from the other side, that aggregate had received an offer for the Stoughton property of 20 million. Not from us, from somebody else. So 20 million was agreed to be the fair market value of both properties because there's a difference between cash and exchanging land. And this is not in the record, but we're talking in the millions of dollars of tax savings. This is not something that is a detailed factual issue. A millions of dollar difference under 1031 of the Internal Revenue Code between a like-kind exchange and a cash sale. That's why it's in there, Your Honor. But that inclusion has no bearing on whether the offer was bona fide, whether the notice was adequate, or whether E&I exercised validly. And they did not exercise in strict compliance. I'm not going to repeat all the facts of Franklin, Feinberg, Christian, the Cornelius case from the First Circuit, but there is no scenario where cash and land can be the same terms and conditions. The common law is substantially the same terms and conditions. These parties narrowed it further through this contract to require the same terms and conditions, and there is simply no way that states a valid claim for specific performance.
Well, we don't know. We don't have a case in the Commonwealth, to my knowledge, that that says that the language, the same terms and conditions, wouldn't be construed, much like withholding consent to assign a lease.
We don't, Your Honor, but we have the Feinberg case, which is one of the cases I really want you all to read, where the right of first refusal used the term match instead of same terms and conditions. And in that case, the holder seeking to push the closing date back 45 days was found to not match. It had a time as of the essence provision. There's one here. And in this ROFR, they were required to accept on the same terms and conditions within 30 days, with time being of the essence. In that case, in the Feinberg case, summary judgment had been granted in the trial court in favor of the holder, and it was reversed on appeal with summary judgment entering in favor of the property owner because they did not validly exercise on the same terms and conditions. This is a legal question.
Well,
whether
it
it's
is,
a
but
Rule 12 motion.
but it's also a procedural question. Because if this were here on a motion for summary judgment, we would be having a different conversation, the one that you have been engaged in for the last several minutes. But the lis pendens statute is really directed at a very different set of questions, isn't it?
Your Honor, I'm not as familiar with you are as the history of the lis pendens statute, but I do understand
before
why
the
it's there.
amendments to the lis pendens statute that imposed or that created the special motion to dismiss, imposed sanctions for someone who had a complaint dismissed. The lis pendens statute didn't include a procedural vehicle for early dismissal of the action, didn't impose the sanctions of attorney's fees. The mere fact that a novel question of law may ultimately be resolved adversely does not necessarily support the allowance, as you contend, of a special motion to dismiss on a lis pendens.
Your Honor, I would disagree because
We can disagree.
If a holder runs into court having not validly exercised, seeking specific performance, meaning they were ready, willing, and able to perform, and they go get a lis pendens and tie up a property for 2-3 years, maybe more, while the parties litigate, so that the owner can do nothing with it. That is exactly what the lis pendens special motion to dismiss section C is designed to protect against. This is a claim where the party did not validly exercise. They didn't turn their corners squarely to look to a 40-year-old phrase.
That's
Strict
your argument, and
compliance
I understand
is
the
required.
argument, but it is premised on a legal theory that has no clear guidance under Massachusetts law.
Your Honor, I certainly think you can look. There has been no case in Massachusetts where a party has sought to substitute cash for a land swap.
No, now there's this one.
Now there is this one, but that does not erase what's been said in Uno Restaurants, Feinberg, Franklin, Christian, even Cornelius, if this court was to look to the First Circuit in its detailed discussion of whether a holder had to include a liquidated damages provision in its offer to meet the same terms and conditions, and that was a thorough discussion of this issue. This is a legal question, and it's one that can be decided at this stage.
Which of those cases that you've just identified, first of all of them, as you know, involve different facts and different asymmetries between the competing offers.
Of course, Your Honor.
But which of them was decided on a special motion to dismiss?
None of them were decided on a special motion to dismiss, Your Honor. However, if I may, the Farello case from this court last year was a case in which this court affirmed that there was no non-frivolous argument for specific performance, no non-frivolous argument that the plaintiff had complied with its contractual obligations. That was affirmed on appeal, and that's our argument here.
And that was, what was the citation for that case?
That is the Farello case from the appeals court last year.
And page?
It is 101 Mass App Court 566. And that was Justice Ditkoff is the author of that decision.
Oh, I remember that case, I do.
So I see I have a few minutes left.
Let me just ask you this question. Do we know why that reference to the $20 million was in the notice letter?
Your Honor, I know I did not write the notice letter, and I don't know what went into its inclusion. But I would suggest to you it's legally irrelevant to whether there was a bona fide offer, whether there was adequate notice, and whether E&I validly exercised.
But just in terms of human nature, it tends to suggest if you come up with the $20 million, then we got a deal, doesn't it?
It's not a sentence I would have put in there, Your Honor. However, we have a right of first refusal with a clause within it that any amendments or modifications need to be in writing and signed by both parties. So the cover letter is not legally relevant to the analysis here. And certainly, when the letter agreement was sent to E&I, there was an ask for a release or a waiver of some kind. You can see that in the record. And there would be an opportunity to negotiate here. And what you had was a party exercise on fundamentally different terms and conditions and run into court seeking specific performance when they were not ready, willing, and able to perform. And that is the fundamental flaw. I know, I see I have a minute and a half left, and I do just want to briefly speak to the implied covenant here, and I want to make just 3 points that I'd ask you to take away here, all focused on reading the verified complaint. One, Your Honor, it was not put at issue by E&I. The implied covenant is not pled as a separate cause of action, at least in federal court under the First Circuit case. That would be a fundamental problem for them. Second, we know from Uno Restaurants that in the absence of collusion, the implied covenant is limited to adequate notice. Here, collusion was not alleged factually. If you look at the verified complaint, paragraph 49 is the only allegation of a breach, and it's in refusing to sell. This is a Franklin v. Wiley footnote 8 problem where it was not put at issue, and then the fact that an agreement contains certain contingencies carries with it no implication of bad faith. Second, Your Honor, the record is undisputed that there was no collusion. Okay? Edwards swore in paragraph 6 of its affidavit to the contrary, and there was no verified allegation on information and belief or otherwise that would create a live issue there. E&I did not ask for discovery on that issue in the briefing, as was its right under the statute, and the lower court decision did not even discuss good faith and fair dealing. We think it was appropriate for dismissal factually on this issue. Finally, Your Honor, there cannot be specific performance, and I think I alluded to this earlier, as an appropriate remedy for a collusive offer. It's either the offer wasn't bona fide in the first place or there's a claim for damages. Uno Restaurants is a damages claim for breach of the implied covenant. In theory, one could...
Thank you.
Sure.
May it please the Court, good afternoon. James McGrath for E&I 131 Commerce Way. I feel as if the Court has already made a lot of the points that I wanted to focus on
do
in
you want
argument.
to talk about the Internal Revenue Code?
Well, the Internal Revenue Code, I think the fair market value that the parties included and agreed upon.
Are you familiar with like-kind exchanges?
As a term and condition would have taken into account the tax benefits that they would have realized through a land swap. And they could.
How so?
Well, if
we start from the premise that your offer, or at least your claim of equivalency, derives from, if we start from the premise that the land was worth $20 million, then a purchase at $20 million was going to have significant taxable gain that would be realized in a cash transaction that would not be realized in a 1031 swap.
Well, that's obviously a question of fact that has to be addressed below, Your Honor.
How is it a question of fact?
Because when the parties agreed upon the fair market value below, they may have taken into account the tax benefits that would have gone with the transaction that they structured. This is not a situation where E&I, like the many cases that Mr. Furman cited, where the party injected a new term or condition into the offer.
I thought you were basing your assertion that the offer was the same or equivalent on the premise that it matched the value of the other offer.
Well, our argument is based on the fact that we met the offer that we were presented with, Your Honor.
On what, and so walk me through the sort of, the logical elements of that contention.
Sure, sure.
As it relates to value.
Sure. So what's undisputed in this case is that we had a valid ROFR, that this was a bona fide offer, that we were entitled to notice and an opportunity to match it. And we timely timely notified the seller of our intention to exercise it. The only question is, whether we offered to match on substantially the same terms and conditions.
Right.
We were presented, this is not a situation where it was a pure land swap and we were making a decision as to what we thought was the commensurate value. Edwards decided as a sophisticated party that it was going to include as a term and condition in the offer that we were presented with the fair market value of the property.
Right, so that gets me back to the, inherent in your claim is the premise that they established the value of the property they were providing at $20 million, and that therefore you would meet that with an offer of the same amount of cash, and then we get back to Section 1031.
That's not our argument. That's what they said in their notice, Your Honor. And in their notice, which they sent to us, they referenced the agreements, both the ROFR and the aggregate offer, and they say, per the terms of the agreement, Edwards is to provide written notice to EGV, our predecessor, that he has a bona fide offer, and EGV has 30 days to elect to purchase, not match, not swap, not exchange, purchase the same in accordance with said offer. Aggregate has had an offer on their real estate in Stoughton for $20 million, and the parties are in agreement that $20 million is the fair market value for both properties. Whether they were going to get tax benefits, Your Honor, is irrelevant to our decision. It's irrelevant to your decision, but it's not irrelevant to the seller's decision. The seller could have included a term.
But the form and terms of the notice don't vary the form and terms of the first refusal right, right?
Well, they certainly reflect the party's intention. This is a legally operative document. We were entitled to have notice, and the notice was instructing us what Edwards wanted us to do. Edwards was saying to us, you have the right to purchase in accordance with said terms. The fair market value is $20 million. To Judge Hodgens' point, wasn't that an invitation? What is the possible basis, the reasonable basis for including the $20 million in the notice to us? They say it was for tax reasons. That's nowhere in Edwards' affidavit. That's an argument in their brief. But okay, maybe that justifies putting it in the offer. Why is it in the notice to us? The reason it's in the notice to us, if you try to marshal the cases that we have to look at together, is because the SJC in the Uno case says the seller is obligated to protect the ROFR holder's interest, number one. Number two, Edwards has said we're entitled to a notice and an opportunity to match it, okay? So Edwards may have said, okay, well, I have to give them a value. So if they want to exercise their ROFR, if they want to protect the legal principles that the SJC has espoused, they can do it. And I can tell you, the record before the court is limited, but discovery in this case is ongoing, and we plan to submit evidence that that's exactly what happened. And we'll do that on a full record at summary judgment. The litany of cases that Mr. Furman cited are all based on unique, different circumstances, but most importantly, were decided on a full record at summary judgment or trial.
You just used the word unique. And of course, you're aware that there is a lot of through lines in real property law that talks about the unique character of parcels of land. It's what we use to justify specific performance on a contract of sale. How does the uniqueness of land bear on the question of the applicability of cash as an equivalent to a proposed land swap, quite apart from Section 1031?
It would be more relevant, I submit, Your Honor, if we were deciding the Castle Properties case, where the court was presented with a pure land swap where the parties to the underlying transaction hadn't included the fair market value. I think that,
Well, every parcel of land has a fair market value. Isn't that incidental to the question of whether it is unique or capable of being, I mean, you know, it's an interesting question whether you could pull any generic $20 million value piece of property and submit that rather as a swap potential rather than $20 million in cash.
I mean, I think Edwards has conceded that point. In its reply brief to this court, Edwards says that we could have offered comparable property.
Well, that may be a binding judicial admission in some settings. I don't know whether it is or it isn't, but it certainly doesn't determine the question of law, which, again, I will confess that I find quite interesting.
Yeah, I mean, the question is, do we have an arguable basis in law for our claims here today? And the question you're asking is, can we offer cash where parties are exchanging inherently unique pieces of property? We say yes because we were proffered with a $20 million fair market value. The Supreme Court of Alaska, in the case that Edwards cited originally below, said in those cases, even though the property is unique, in order to honor the rights under a ROFR, you should have an opportunity to offer the commercial equivalent.
And
we're not saying...
Isn't that, if that's true, wouldn't it also be true if the proffer, if the notice letter about the right of first refusal was silent on the question of valuation?
Well, yes, you know, but that's not a case this court needs to decide because that's not the circumstances here. You know, that if the court wanted to adopt the Alaska Supreme Court's approach, it would be consistent with the Uno case that I cited and the fact that the ROFR holders should have an opportunity to match. Otherwise, the parties to this transaction could simply avoid our ROFR by having a land swap.
Or you could write that into the right of first refusal.
You could, which the parties did not do here.
Correct. I mean, you know, as you know, a right of first refusal is a very, very limited, I mean, compared to an offer to purchase that is accepted, compared to an option, the right of first refusal is fraught with all kinds of different limitations. This may be illustrative of a very significant one that parties would be well advised to draft around.
Correct, but all of the frailties of an offer or of a right of first refusal, in this case, at this juncture, we've assumed that they were all met. The parties agree that there was a bona fide offer, that it triggered the right of first refusal, that it was presented to us. So it ripened into an option. We got to the last step.
Well, let me just make the observation that maybe this is too obvious that I'm wasting time by even offering it, but the fact that an offer to purchase for the same amount of money using financing is not equivalent to a cash offer.
Understood, but that's not...
The differences between a swap and a cash sale are much greater in nature and in substance than the difference between a financed purchase at the same price on the same date compared to a cash.
And I submit that would be a harder question to grapple with if the parties to the underlying transaction hadn't included the fair market value, because they were providing that alternative. This is a hybrid approach. It's not strictly a land swap where they've said, you know, these are the only terms and conditions of this deal. And that's what we're presented with. Did we exercise on substantially the same terms and conditions that were in the aggregate offer? So it wasn't just a straight land swap. There was a $20 million valuation in there. Why? The question is why. The discussion we're having here today, I feel like, is the discussion we should be having after final judgment in probing into these questions, because clearly there's a reasonable basis for in fact for our claims, and there's clearly an arguable basis in law. Mr. Chief Justice, you recognized at the beginning this is a novel question that's not susceptible to dismissal under the special motion to dismiss standard. And so, you know, we have a unique situation that was created by the parties to this transaction. They included the $20 million. So the issues about the uniqueness of property and whether a cash offer is equivalent or it's like us inserting a mortgage contingency, Those are questions that the parties to the underlying
No, you're
transaction
talking about a
answered.
mortgage contingency. I'm just talking about a financed purchase.
Finance to purchase. Well, I guess the point I'm making is, this is not a situation like all the cases that the defendant has cited, where there's some different condition, or different term, or different closing date that's been inserted. This is a case where E&I didn't inject anything. We simply looked at the offer we were presented with, we looked at the invitation and the notice to purchase, and the amount that was set forth if we wanted to purchase, and we exercised in strict conformance with those documents. So we haven't done anything different here, and clearly at this point in the proceedings, you know, we have stated an arguable basis in law and a reasonable basis in fact, and the trial judge below certainly didn't abuse his discretion in reaching those conclusions. So I think at this point, the case law that we have in Massachusetts clearly is consistent with the position that we've cited with respect to protecting ROFR rights, with respect to giving us an opportunity to match. The case law that defendant first cited from Alaska certainly gives a structure that the Massachusetts courts could arguably adopt. Whether they ultimately will or not is not the decision that needs to be reached today, but there's clearly an arguable basis for that, and it's not us just saying we should have an opportunity. We have a Supreme Court of another state setting forth a path to where we want to go. And then finally, I would just say, on this record, you know, there's no reasonable basis for why they included that $20 million in the notice that we received, other than to give us an opportunity to exercise at that price. Thank you for your time.
Thank you. Interesting case. That concludes our argument session. We are adjourned.